Solutions, LLC.
Good morning, Your Honor. Joseph Herbert, appearing on behalf of Sheffa L L C, the defendant.
All right, welcome to you both. We're here for a hearing on the joint statement of discovery dispute regarding the deposition of Erwin Pasternak. I reviewed your joint statement and the emails that were attached. So I wanted to kind of give you my thoughts. Rule 30D is the rule that governs the duration of depositions and also the extension of a deposition beyond the 4 hours. And it can be by agreement or by court order. Here, based on what was relayed to me, it sounds like there was an agreement to extend it to 5 hours and that it was cut because of health issues at 3.5 hours. It also sounds as though there was an agreement to reset it for tomorrow at 10 a.m. So I'm inclined to enforce that agreement, but I'll hear you both out on that issue and what you have to say as to whether or not it can go forward. So I'll start with you, Mr. Herbert.
Yes, Your Honor. I assumed that the court set this expedited hearing, treating it as a discovery dispute because of plaintiff's statement in his purportedly joint statement of the discovery dispute on the basis that there was a stipulation to extend the deposition and agree to a later date. As I pointed out in my emails, and I apologize, there are a few typos in there and some misstatements of letters. I wasn't driving. I had pulled over. I was stopped on the side of the road, but not in my office. But the important part, Your Honor, is that I challenged Mr. Rowland to tell me where there was a stipulation in that regard. At the time it was filed, Mr. Rowland maintained that at the end of the deposition on the record, we agreed to some kind of a continued deposition date. And in the interim, of course, I urged him and reached out to the court reporters to get a copy of the transcript. And the transcript revealed that there was no such stipulation. The only reference to it was earlier on, and I apologize, Your Honor, that's one of the reasons why this shouldn't be treated as an expedited discovery dispute, because there are documents and some case law that needs to be addressed that don't normally come up in these types of situations. But at any rate, starting at the beginning with the court reporter's transcript, after lunch when they came back, and it says, we are back on the record, time is 1:37. There was a couple questions, and then after that, there was a statement by Mr. Rowland. It says, after we broke the last session, we spoke off the record about the medical condition may prevent you from finishing the deposition today. We may have to end early. So if that's the case, we'll go on for as long as we can. I'll just relay that. I'll just rely on you to let me know. Response, okay. When your medical condition requires you to stop, okay. And then we'll find another time to finish the deposition. That was at 1:37. That was the last discussion that was had. The deposition wasn't terminated early. I also reached out to the court reporter and obtained from him his email from Dennis Woods of Coach Reporting that states, per your request, the deposition started at 10:07 and concluded at 3:04 p.m. If we're mincing words that there was a 3-minute difference in the 5 hours, Your Honor, then we're wasting our time here, I think. Importantly, the rule provides that, starting with, it's 4 hours and it's concluded in 1 day. And Your Honor,
But
again,
let me ask you this, because the trouble I have is that it sounds like you had some conversations after that with Mr. Rowland and didn't object to his rescheduling it for the 14th until this past Monday.
That is not correct, Your Honor. That's a misstatement of the facts. Initially, there was been some conversation that if it had to go forward, then we could reschedule it. After the deposition concluded, and if I can finish, Your Honor, by the way, at the conclusion of the deposition, it was ended. It went off. We're done. We're going to cut it off today. Okay, thank you. That's because you're medically needing. He says, and the answer was, yeah, I'm tired. I'm tired. I'm shot. I'm done. The videographer said, are we going off the record? The last exchange was, we're off the record. Did you want a copy of the transcript? Obviously, the court reporter considered that the deposition concluded. It was 5 hours. At the end of it, while we were sitting around, Mr. Rowland got into a conversation with Mr. Pasternak's wife, who happened to be in there. And they had a conversation where she volunteered that she was out of town. I, at no point, had a conversation with Mr. Rowland where I contemplated that I would continue the deposition. It was supposed to be 4 hours. Mr. Rowland, in an email, said he thought he would go 5 hours. I didn't object to that. We went 5 hours, and the deposition was concluded. If there was a stipulation, it should have been. I mean, we're sitting there with a court reporter. That would have been the time to have put that on the record. And I guarantee that if there was an attempt to put that on the record, we would have been having this conversation last Monday, because I've been doing this a long time, Your Honor, and I know that this is a ruse that happens all the time, and people try to extend it. They get to the end of it, they let them finish up, and then they say, oh, we have to come back. And because of that, I have argued this issue many times. Again, Your Honor, I apologize. You're not looking at, but I'm reading from the Arizona Civil Rules Handbook.
I have it open and in front of me too.
Okay, well, if the court looks at the comments to Rule 30 at the end, initially under paragraph 3, towards the end of it, it says limitations rate number of deposition hours. Rule 30D provides that unless the parties agree, a deposition is limited to 4 hours and must be completed in a single day. There was no such agreement, although admittedly, I didn't object to it, and I'm not here arguing.
It says unless you agree or the court orders otherwise. It also, under subsection D2, says that one of the bases that I can sanction is an unreasonable refusal to agree to extend a deposition. So why don't we talk about
what, Your Honor?
Why you won't allow the additional hour and a half?
Well,
maybe clarify this. Did you said you read a part of it where it suggested that your client, Mr. Pasternak, did say, I am done, I can't go on any further because of medical issues, which sounds to me like it was cut off because of his issues, not because it was truly done.
Well, Your Honor, regardless, if under whatever circumstances, it should have been done at 4 hours. It was done at 5 hours. And if I direct the court's attention to read a little bit further down in the McCullough's comments, the very next paragraph, paragraph 4, where it says exceeding presumptive discovery limits. It says, in those circumstances where a party or parties conclude it is necessary to exceed the Rule 30 discovery limits established by the assigned tier, Arizona Rule of Civil Procedure 26.2 G and H set forth the procedures for exceeding such assigned limits, and not Arizona Rule Civil Procedure 26D, the expedited procedures for resolving discovery and disclosure disputes. In that latter regard, by its terms, Rule 26D procedures apply only to disputes between parties to an action that could properly be addressed in motions for protective order under Rule 26C or motions to compel discovery. I'm assuming you're reading along with me. But it goes on to say the Rule 26.2 allows parties to obtain discovery beyond the assigned tier limit, either by way of motion or stipulation. And it further states, if the additional discovery is sought by way of motion, then Rule 26.2G provides that the motion state the reason why the requested additional discovery is necessary, establish the requested additional discovery is proportional, 3, attach a copy of the requested additional discovery or describe the anticipated deposition testimony, and 4, attach a Rule 7.1H good faith consultation certificate. To answer your question, Your Honor, this case started in 2024. We have gone through 170,000 pages of disclosed documents. Mr. Pasternak sat through the deposition despite, I hope we have an opportunity for you to see him in his distress condition, sitting there for 5 hours and being involved in this for 5 hours to answer questions that are routine, mundane questions that should have been resolved in the first month of this proceeding. So my objection, Your Honor, is these ploys are designed to dissuade, abuse, object. That's the whole reason why Rule 20, all of Rule 26, Rule 26, 26.1, 26.2, those rules are created to protect people like my client from unreasonable and unnecessary issues involving in the litigation. The courts, the Supreme Court's determined that that's the 4 hours. That's what they should have. Mr. Rowland had access for 5 hours. There's to require him to come back, Mr. Pasternak, to come back after testifying, which I can go into the thing, that he had little or no knowledge of the stated issues that were spelled out in the Rule 30b-6 notice of deposition or subpoena, and having spent 4 hours on the record going over mundane documents in an unhealthy situation. I think the question should be, Your Honor, why does Mr. Rowland need more time? He knew what his time limit was. He stated it. He was the one that created it. He was this. If Mr. Rowland wants to go through the deposition transcript and indicate that there was any obstruction or delays or anything that was done on our part to make his planned 5 hours of deposition not possible, then that should be addressed, and I would certainly look forward to him trying to do that, because I didn't say 50 words in the whole time. This is just, the rules are very clear, Your Honor, that this is designed to be a presumptive 4-hour deposition. This one went 5 hours, and there should be a reason why you require an 80-year-old man in poor health conditions to come back and answer mundane questions that were addressed. By the way, the other comment in my email was just after the next day, actually 2 days, on Wednesday, Mr. Rowland deposed Nate Sanoski, who's the actual guy who was involved in all this stuff. He went through the full deposition with him. At the beginning, we haven't gotten that transcript back, but Mr. Rowland can't deny that at the very beginning of the deposition, Mr. Rowland asked Mr. Sanoski if he was the one who was knowledgeable about the topics that were set forth in Erwin Pasternak's 30b-6 deposition. Mr. Pasternak had already testified that he was the owner of the company, but he didn't have direct personal involvement in it and had a poor recollection of it at any rate. Mr. Sanoski, on the other hand, testified that he was fully apprised of it and was involved in the situation, and we sat through that deposition. Mr. Rowland had the opportunity. Mr. Pasternak was the first deponent. There were 3 other deponents in the same week, which, by the way, again, we're going to be pushing the 15 hours, you know, if we go any further than this. And Mr. Rowland had the opportunity to address his concerns. If this was truly a fact-finding mission, which is the purpose of a deposition, then he had every opportunity to do that. And if he wants to reveal to the court why there's some special thing that he couldn't get out of Mr. Pasternak in the entire time that he was available for his testimony, I think he should have to spell that out to the court. And I don't think we should just, I mean, these rules are created for a reason, and it's to protect people like my client. And I think there should be a really good reason. If we get to the point where we're just going to, we should go a little bit, yeah, we're going to fudge it, it's a slippery slope. And on that issue, Your Honor, again, because I've done this a few times in my life, I would note that Mr. Rowland he wants him back for another 90 minutes. So he's
Okay,
gonna.
I think I got the gist. You've been talking for about 15 minutes, so I need to hear from Mr. Rowland. Mr. Rowland, what I need to know from you is I do have to consider that this deposition sounds like it went for a long period of time, even if you have some disagreement about how long that period of time was. If it did in fact have to be adjourned because of medical issues, then I have to take that into consideration when we're talking about bringing this gentleman back down for more time. So why, what do you need to depose him on for an additional hour and a half? Why is it critical for him to come back for that additional time?
So I'll just try and stick to the key points that I think are important. One correction that I would make to Mr. Herbert, he said several times that Mr. Pasternak sat there for 5 hours and was deposed for 5 hours. The on the record time was 3.5 hours. Mr. Herbert is counting breaks and a lunch break, a 1 hour lunch break. That would be the first time I'd ever heard anybody try to include that in deposition time. The parties broke for lunch, we came back. The actual on the record time was 3.5 hours. So I need another 90 minutes, which would bring me to the 5 hours that I projected in advance and let Mr. Herbert know, for the courtesy of him and his client, that I would need 5 hours to depose this witness, to which he did not object at any point. And I just want to finish that time. Now, I'm happy to speak as much as you'd like to hear about the topics I need to wrap up asking him about and the split of 30v6 topics. Before I get to that, I mean, I think it is clear, and Mr. Herbert read it, that there is an agreement on the record. He had a medical issue. He told me, I'm going to have to stop early. And I said, okay, if we stop early, we'll just find another time. And he said, okay. And then later he said, I'm done. I'm shaky. His hands are shaking. And I'm obviously not going to interrogate a nearly 80-year-old man about his medical condition and force him to sit there. I'm going to say, okay, fine. We will stop immediately. I see you were about to ask a question, so I'll pause.
What I wanted to ask is, you're acknowledging that you don't need that much more time with him. Will you make an accommodation in light of his age and medical issues and conduct tomorrow's remaining deposition if I allow it remotely?
I don't think. Oh, I'm sorry.
I would. We have a videographer. I'd have to double check with them. I'm sure that they could make that arrangement. I'm not sure what COASH requires for remote videography sessions. I think they usually have to have the videographer. I'm not sure. I'd have to check. I'm okay with that as an accommodation if that is required. But I would have to double check with the court reporter.
And I don't need you to go into gross detail about why you need the extra time with him, but can you tell me generally why, when you've conducted all these other depositions, and what Mr. Herbert is telling me is that there are other witnesses who have covered the topics, the 30b6 topics, and are more knowledgeable about them. Why is Mr. Pasternak important on, and what are the topics that you intend to ask him about in this additional time? And
Mr. Herbert touched on 26G tiering, which I think just applies to the total hours of deposition time, which we are well short of the total deposition time allotted for tier 3 cases. I think about 10 hours, another 90 minutes would get me close to 12 hours, well under that time limit. In terms of what I need to finish my questioning on for Mr. Pasternak, there were 4 employees of the defendant that I wanted to depose as witnesses, and I also issued a 30b6 notice outlining a number of topics. And I told Mr. Herbert, I imagine that some of these witnesses that I'm otherwise already going to depose may be designated as 30b6 representatives. So let me know how we'll split up the topics, and we'll do the witness deposition and 30b6 aspects of deposition simultaneously so as not to inconvenience anybody. We worked that out. We figured out who was going to be deposing, representing the defendant as to what topics. Erwin Pasternak was designated to speak on about half of the topics, most of the substantive ones, and Nick Sanowski was designated for about the other half. It became very clear, however, within the first 30 minutes of the deposition, Mr. Pasternak revealed he'd been diagnosed with a cognitive impairment condition, and that he was therefore not comfortable and unable to provide testimony on behalf of the entity. Okay, fine. He's no longer the 30B6 rep. I proceeded as best I could to depose him as a witness. Due to his memory issues and cognitive issues, frankly, the questioning took longer than I even anticipated it would, because I'm having to refresh his recollection. I'm having to close the loop on what he knows and doesn't know. Nonetheless, I do think that I can still get it done in the originally allotted 5-hour time. What I want to talk to him about is this case involves a lease amendment. At bottom, involves a lease amendment executed between my client as a tenant and Mr. Herbert's client as the landlord. I got Mr. Herbert's client. Their position is that the construction of another building delayed their ability to deliver the premises to my client. So I was able to get through a lot of questions regarding the construction of that building and that relationship. I did not even get to the negotiation of the lease amendment, which is the subject of the lawsuit, and who Mr. Pasternak is the only individual that was involved in negotiating. Mr. Sanowski, although he was designated by Sheffa as a 30B6 rep, testified that he was not involved in those negotiations and had no personal knowledge and had done no research to prepare himself on what was said or heard during those negotiations. So, okay, fine. Sheffa has no testimony on that subject. I would still like to finish my deposition and questioning of Mr. Pasternak, the individual involved in those negotiations. And that I think I can get done in 90 minutes or less.
Your Honor,
All right.
if I may.
You may, but before we
I'll keep
get
it brief.
there, answer my question, which is, if Mr. Rowland will convert this to a remote deposition, so your client doesn't have to physically travel again to his office, and it's limited to an hour rather than an hour and a half, why can't your client appear remotely on video to finish it up for an additional hour tomorrow?
The reason I balked at the outset, Your Honor, is that, again, we're talking about an 80-year-old man who's living with his wife. This is not. I mean, I don't have the facilities to set it up in my office. I've never done that before. And I guess the bigger question and the point I wanted to make, Your Honor, is the reason this should be by way of motions is so that we're not sitting here saying things that aren't factually accurate. If the key issue here is regarding this amendment, I've already read Mr. Pasternak's transcript of his deposition, as I'm sure has Mr. Rowland, and it specifically says Mr. Pasternak didn't negotiate it. He hires a broker side. He signed it. He doesn't remember looking at it. And Mr. Rowland, I'll refresh your memory, because his response was, I have 80 leases. No, I don't remember it. So we've gone, that row's been hoed. This is just to bring him back. There was every opportunity to address this issue at the time. And the interesting thing, Your Honor, is the majority of the time that was spent was all regarding, and again, this is important, because if we do have a hearing on this, Your Honor, and we do have a motion on this, I will provide the court with the court transcript that indicates Mr. Pasternak's testimony basically is numerous times of Mr. Rowland saying, did I read that correctly? On documents that aren't even relevant to the proceeding. Regarding needy construction, they weren't even parties to it. They had no way of knowing it. It wasn't even available to them until after the commencement of the lawsuit. It was obtained through discovery in the lawsuit. These are, Your Honor, I've been doing it again. I'll say it again. I've done this a long time. I've seen how this works. Everybody seems to want to just say, oh, that's not a strategy and that's not a deal. But the reality is that's why the rules were created. And I would vehemently object to even come back. If it had ended early, then we wouldn't be here. I wouldn't have a leg to stand on. I mean, if Mr. Pasternak had come back and in 15 minutes he said, you know what,
are you disagreeing that his characterization is that it was only 3.5 hours of actual record time, but that your 5 hours is including your breaks and your lunch?
I do, and Your Honor, and that is standard in the industry. I don't know where Mr. Rowland comes up saying that that's not the thing. If you look it up, I mean, interestingly, there's very little case law on it, But all the treaties, all of them say the language is crystal clear. It says is limited to 4 hours. I mean, they want to write in extra languages 4 hours, but that doesn't include breaks or thing. Do you understand the ramifications of that? If you're saying that, then you can bring a deponent in at 8 o'clock in the morning, go an hour, take a break for an hour, go an hour, take a break for an hour, go an hour, take a break for an hour, go an hour, take a break for an hour. You still have him there for 8 hours because that's how it's manipulated. The rule.
Here's what I'm going to tell you, because we've been going for 30 minutes on an issue that I typically don't have to get involved in, because you ought to be able to resolve this amongst yourselves. Realistically, this is not something that you should have to bring to me at all. But because you're here, I want to give you the opportunity to try and resolve it, which is why I'm making the suggestions I'm making, such as trying to accommodate by doing a remote deposition, shortening it from 90 minutes to an hour, which is really only an additional 30 minutes. And the rule does incorporate the requirement that you not unreasonably withhold your agreement to extend as needed. Mr. Rowland has identified a what sounds like a narrow topic. And frankly, Mr. Rowland, I don't think you ought to be spending an hour and a half on negotiations when you've acknowledged to me that it sounds like this witness has some impairments that are not, you're not likely, based on what you both told me, to get anything useful out of a person who doesn't have the ability to recall what occurred. And I don't know how long ago these events occurred or this negotiation occurred, but those are all factors that I consider. I will let you file a motion for a protective order, but if you have to do that, I'm going to decide who is in the wrong and award attorney's fees. And it's going to be another month of delay, which I really would not want you to have to endure, only to potentially have to do what I'm asking if you can agree or accommodate right now without all of that extra expense and time. So that's why I'm suggesting, can you agree to a remote deposition by video, which most people can do from home? You've got video cameras in your offices. That works typically fine, just like we're doing our virtual hearing here. And I would want, Mr. Rowland, for you to make that accommodation in light of Mr. Pasternak's health issues, if I ordered the additional time, and to keep your deposition very narrow to only what is really necessary and only what is within his knowledge alone. In other words, if there's another witness who has better memory and can testify to it, go to that witness. But if you need to talk, Mr. Rowland has made a case for why he needs to at least evaluate whether this witness has firsthand knowledge of these negotiations beyond what other people might know. So I'm inclined to allow an additional hour. I'd require it to be remote in light of this witness's impairments, to make it as to minimize the burden on Mr. Pasternak. But again, if you want me to allow you to file a motion for protective order, I will. But this process is designed to hopefully avoid you needing to do that and the associated delay and the associated expense. And again, if I have to go through those motions and this transcript and the back and forth, whoever prevails is going to get their attorney's fees. So what do you want to do?
Your Honor, I'll answer first. I'm happy to go as you've suggested. I'll make the accommodation to do it virtual if that is in fact easier for Mr. Pasternak. I'll let Mr. Herbert speak to that. It may actually be easier for him to just come to the office instead of set up technology. Either way is fine with me. I'm okay. I will make cuts and keep it under 60 minutes. Certainly, I mean, we're just talking about completing a deposition. I do not see the need to do engage in costly and time-consuming briefing on what is really a small and easily solvable issue.
Mr. Herbert, what are your thoughts?
Your Honor, you've addressed my concerns regarding the rules and whether or not it should be done, and you've made yourself clear in that regard. And so that's a moot point. There's no basis to, we're not filing a motion for protective order. When I was talking about motion, I was talking about if Mr. Rowland filed the motion under 26.2G. So I can't speak for Mr. Pasternak on the issue of what's most convenient, what's easiest for him. I suspect, to be honest with you, Your Honor, again, I'm an old guy. I would rather be in Mr. Rowland's office than trying to do it like this. I had more concern about this hearing than I do the depositions, and I'm sure Mr. Pasternak probably shares my belief. So I think if we limit it to 60 minutes and let Mr. Pasternak have the choice of whether he wants to do it remotely or in Mr. Rowland's office, I'll get on, as soon as we get off the phone, I'll get on the horn with him and make sure that that's something that we can do. And then, as you say, work it out with each other.
All right. Well, thank you both. I appreciate that. Like, as I said, I really just don't, I want to be able to use this expedited discovery just process to save you time, money, and headaches with discovery motions and briefings. So I appreciate your willingness to compromise on both sides on this issue. So what I will do is I will enter the order that the parties that'll allow the continuance of the deposition for 1 hour, and with Mr. Pasternak having the option after conferring with counsel of whether you want to do that in person or the remote accommodation. And then I'll just ask that you confer with one another after, Mr. Herbert, you have a chance to talk with your client to confirm how you're going to go about that additional hour of deposition so that it can proceed. Okay.
And we'll do that today, Your Honor, because I know
Okay.
Mr. Rowland has people on standby to do this, and so we'll get that ironed out today.
All right.
Thank you, Your Honor. May I ask that the minute entry reflect one other specific detail, and that is, you heard today, Mr. Herbert and I have a bit of a difference of opinion about how time is to be calculated in a deposition. If a minute entry could specifically state that it's 1 hour of record time. If it's 1 hour, I don't need to take breaks. We'll sit there for an hour, but I'm just concerned that, if we have a disagreement for Mr. Herbert's client, the clock will start the minute they set foot in our office, and there will be then some dispute about that. I just want to avoid it.
Yes, I'm talking about 1 hour of record time, provided everybody is reasonable, and I hope that will not be a problem. So you ought to be able to get in and out without that being an issue. But yes, 1 hour of record time. All right.
Thank you, Your Honor.
Thank you both. Have a nice day. We're off the record.